Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
Hey guys, it's Squid. Welcome back to the channel. Hope everybody is doing well today. All right, today we have an update on a case out of my home state, out of my home county, the county that I lived in before I moved to Georgia, Milwaukee County. Gotta love it. The judge that went rogue, no pun intended. We have a decision from the district judge on whether her motion to dismiss will go through or not. And it's not like Judge Belatho, where it's a 1, 2, 3 page motion. This is 27 pages of fun. These judges out of the Eastern District of Wisconsin love to write. So instead of just telling you, we're going to share. We're gonna share all 27 pages. All 27 pages of fun. Because Lord knows, I don't know. Oh, and I will not be doing a stream on Saturday. I forgot. How could I forget? It is freaking game week. It is week 1 of college football. And even though Georgia is playing Marshall, and Marshall is going to get their ass kicked by 4 touchdowns, is my prediction. Marshall's a Sunbelt school. I live in a Sunbelt town. Marshall's talking a lot of shit for the size and the conference that they are in, and I can't wait to royally watch them lose and get their ass kicked. So there's that. Also, if you want to send those super chats, today is the day. The little one and I went shopping for new clothes and new shoes for her because she only fits into one pair of her shoes now. And I way overspent. So if today is the day that you want to send those super chats, today is the day where I will grift for my daughter because I blew my budget. I did. All right. Hi, Jeffrey. How are you? Heidi, thanks for doing all your Modly stuff. And yes, this is the judge that decided to let ICE can't be anywhere around her courtroom. And she decided to allegedly, even though it's on video, let a illegal immigrant who was in her courtroom for a misdemeanor battery charge, I believe, leave through the side door. Yeah, you're going to get that in your face and it's not going to be fun. And we also bought 6 containers of bubbles because they were on clearance. So, Angel, go get your, we're not playing with this today. Go get your bubble bubble wand. Debbie Webb, how are you today? Kathy, how is everybody? Ninja Puppy, hello everyone. Going to be listening with headphones today, so please don't think that I'm being antisocial. I'm antisocial every day. So it's understandable, and I will try to keep the little screams to a minimum because I know you were wearing headphones. Sometimes I can't help it, but I do tend to mute myself when she just comes in and screams bloody murder for no reason. And Tammy, hello, good to see you. Ammo girl, good to see you. Good job on that picture earlier. Derailment officially engaged. Roy, how are you? How is the wife? Give her a hug for me. Oh. Let's see who else is here. Malin, good evening, Squid, Baby Squid, Mods, and the fabulous chat fam. Chris, how is everybody? All right, and we are going to get into this because it is 27 pages. I would like to get through all of it. I am going to skip the indictment because the magistrate judge also wrote 27 pages of fun and kind of went into some of the issues and all of the indictment. I'm going to skip over some of that. If you would like to see it, I do have a Hannah Dugan playlist. And I will put the link to the previous videos in the description of this video when we are done. And Tammy, thank you for the $2 super chat towards the shoe fund. Thank you. I went a little overboard though. This was back in, I want to say March or April. See, when I said we bought a lot, she's bringing, go get your flower. Go get your flower. She has a bubble flower. So she has a bubble pew pew too, and a bubble flower, and I refilled it today, and she's bringing me these. Go get your flower. Angel, go get your flower. She brought me another container of 6 tubs of bubbles. Thank you for the 10-pound super chat. 6 tubs of bubbles that would last 30 minutes in my house. Well, I originally wanted to buy this is 32 ounce. I wanted to buy the 64 ounce one, but the 64 ounce one, make this make sense, Walmart. Usually when you buy a bigger container, it is cheaper. The 62 ounce one or the 64 ounce one was $2. This one was 75 cents. If you do the math, and this is where they get people, if you do the math, 64 ounces of these is $1.50. This is where, the math, you got to do math when you go shopping. Like, you can't just pick stuff up and assume that because you're buying in bulk, it's cheaper. No, and this is where my couponing side comes out, because yes, back in the day, I was that kind of person who would go to double coupon days and get like $150 worth of groceries for like $55. I was that person. So I ball on a budget for a reason. You shouldn't gamble away your money. Baby Squid needs a new pair of shoes. Oh my goodness. We were supposed to be at day 2 of round 4 of chemo, but the hospital can't mix it until the equipment gets replaced next week. So it's been rescheduled until September 10th and 12th. We will also be at the hospital on September 11th. Mr. Squid has a procedure on the 11th. So I will not be streaming probably the 10th or the 11th as he preps for that procedure and has that procedure, because now we did it 5 years ago and I took him to the hospital and I waited there for him. But now, having a toddler, it's going to be even more fun trying to figure out the logistics of all that. So, people do not pay attention, and that is where they get you. That is where you get screwed. It's Ninja Puppy, thank you for the $4.99 super chat. Shoe grift, shoes ain't cheap, headphones off as dinner's been decided. Sounds good. I did buy, when I buy her shirts, I do buy a size bigger because one, who doesn't like an oversized t-shirt or a sweatshirt, and that way she will grow into it, and I don't have to buy as many things. She has some 3T stuff, but a lot of it I buy in 4T, so that way she's just wearing an oversized shirt, which is fine. So we got a bubble squid and a lawnmower and the bubble rope. She broke the bubble lawnmower. She got a bubble lawnmower not this year for her birthday, but last year for her birthday from my sister-in-law, and she pushed it around so much she broke it. All right, now that everybody's here and we've gone through that 10 minutes of letting YouTube actually send out notifications. Last night I got a notification for Shizzy's morning show. I can't Morning Whiz at like 8:30 at night. So if you're new to YouTube, that's one of the reasons that YouTubers like don't get started immediately. It's because YouTube takes their dear sweet time with sending out notifications. So if they're talking about an important subject like this, we will take care of housekeeping things before we get started on the topic at hand because YouTube kind of gets a little wonky. So, you know. Hey, King Paco, how are you guys? We are doing all right. My neck is a little sore today. I don't know. But other than that, we good. Ancient Drummer, how are you? I haven't seen you in so long. How are you doing? It's so good to see you. I love when I get to see people who either usually can't make a live and are on replay crew or just haven't been able to watch in a while. I love you guys. I love you guys. All right, we will get started with this. Children's Jeffrey, you're funny. Children's toys are easy to break because they're cheap, and we know that children are not kind to their toys. Let's put it that way. That's as politically correct as I'm getting with that one, but my child runs her toys into the ground and then some. I have toys that I would like to give that are quality to either the ABA clinic that I work at on Tuesday nights. I'm not an ABA therapist. I just help clean the place. I'm one of their janitors. But I clean an ABA clinic. So if you don't know what ABA is Applied Behavioral Analysis. It's a clinic that is specifically set up to treat autistic children not treat them as like, you know what I mean by treat. Helps with toilet training, helps with develop social skills, self-feeding, just the issues that autistic children have. It develops them together in a group, individual. The kids are really hard on toys. So I've decided that all the toys that we no longer use, I'm donating to the ABA because they go through toys like nothing. Although I gotta say, it is really difficult when I go in there into one of their playrooms and I see Baby Squid's old toys, and it pulls at my mama heartstrings a little bit, and I'm like, oh, I really hope the kids are enjoying it. But at the same time, I'm like, I know they're being put to good use. So, yes, help them learn to be self-sufficient. Potty training. Like, I'm kind of working on potty training. We kind of shut it down a little bit for behavioral issues, but like things that parents can normally do on their own, they just need a little extra help with. Some of the kids are there 40 hours a week. It's like it pulls at my heartstrings. Yeah, I just clean the place. My friend owns a cleaning business, and literally I just clean it. Yeah, social skills, anything that the children might need, they develop goals, kind of like OT does. In the past, OT and ABA have kind of butt heads a little bit because ABA can sometimes get a little if you don't go to the right clinic. So the NBCOT, the National Board Certification for OT, kind of doesn't like ABA. partially because they kind of step on each other's toes. I, however, am like, as long as the children are being put first and cared for and treated with respect, you do you. Yeah. So, you know, they have their goals and the therapists do their things. I can't work with children. I get too emotionally invested to a fault with children. So, yep. Some of them they can't help till they're teens, and 2% you can. Yeah, and even it's not even all about the kids sometimes, it's about the parents. Teaching parents strategies for changing diapers without a struggle. Um, how to interact better with your kids when you have to go out shopping and you have to bring your children with you. How to manage all of the extra noise, because shopping is an overwhelming experience with a child, let alone a child who gets overwhelmed easily, like an autistic child. So it's a very rewarding thing to watch. But at least I have a place to go with all these toys. So I know that the toys are at least being used, because I don't want to throw them away. And I also, like, a lot of them aren't worth trying to sell. Um, it's just not. We're not having a garage sale anytime soon. And hey, Dad, how are you? Uh, all right. We are gonna get into this. And Dad, this is about Hannah Dugan, the judge in your county. This order was put out on Tuesday. Ugh. All right. And I am going to skip, like I said, some of the bigger parts because this is 27 pages. We only got so much time in the day. All right. Defendant Hannah Dugan moves to dismiss the indictment charging her with concealing a person from arrest, 18 U.S. Code 1071, and obstructing removal proceedings of the Department of Homeland Security, 18 U.S. Code 1505. Summarized, the government alleges that the defendant, a state court judge, concealed from arrest and obstructed the apprehension of a person wanted by federal immigration authorities for removal. The magistrate judge handling pretrial proceedings in this case issued a recommendation that the motion be denied. Defendant objects, requiring me to review the matter de novo. Federal Rules of Criminal Procedure 59B. Here's the indictment. Count one was April 8th. It was April 18th. So there you go, Malin. April 18th. Hannah Dugan knowingly concealed EFR, a person whose arrest, a warrant, and process had been issued under provisions of law of the United States, as to prevent the discovery and arrest of EFR after a notice and knowledge of the fact that a warrant and process had been issued for the apprehension of EFR in violation of Title 18 U.S. Code Section 1071. So obstruction, directing EFR and his counsel, not just the person in question, but also his lawyer. No. Through a non-public jury door. And then advising EFR's counsel that EFR could appear by Zoom for his next court date. This part, I don't have. This, I think, is within her jurisdiction, the appearing by Zoom. I have no problem with that. It's this first part. And the part about telling ICE they had to go to the Chief Justice's office and knowing he wasn't there. So there's that. In her motion, defendant argued that 1, she enjoys absolute judicial immunity. The worst phrase in the English language, in my opinion. There's no such thing as absolute judicial immunity. For the official acts alleged in the indictment, this prosecution violates the 10th Amendment and the Constitution's vertical separation of powers by intruding on the authority of state judges to manage their own courtrooms and proceedings. And 3, 1071 and 1505 should be construed as to avoid the constitutional issues she raises. The magistrate judge concluded that while the Supreme Court has granted judges immunity from civil liability, no such rule has been established in the criminal context. She tried to say everything she cited was civil. Civil, 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 civil. This is not civil. This is criminal, you dumb. See you next Tuesday. The thunder cow of this judge. Like, look at my thumbnail. She even looks like a thunder cow. Like, if you were to... She looks like a Fleesa reincarnated, if Fleesa had teeth. She further concluded that defendant's 10th Amendment claim required the assertion of disputed facts and characterization of the events underlying the indictment, which could not be done on a motion to dismiss. Finally, the magistrate judge rejected the constitutional avoidance argument as identified no ambiguity in the charging statutes. Like, one thing she should be in jail for is what she did without a trial because of what she did. So the government is, in the original indictment, is not looking for jail time, which personally I think is BS. However, with that being said, when you're charging a circuit court judge, if you try to, my assumption would be, this is just my assumption based on how the government works and who's got hands in whose pockets. If you try to ask for too much, you're going to get nothing. So being charged and being found guilty and having to pay is still going to be on her record versus if you tried to go for jail time and a jury or a circuit or a federal judge was like, this is a bridge too far, and cut your case down. So I believe that the U.S. is going for what they can get and not for what they actually want. It's one of those things of what she deserves and what we want to give her as punishment and ask for punishment versus what is realistic. And that's the, if you don't mind me interrupting the stream, how's the new chunk of metal working out? Not too bad. I'm thoroughly enjoying it. I appreciate it. And thank you, Dad, for my new computer. That is my birthday present from my dad. His birthday is coming up in a week and a half, and I still have no idea because my father, just like Mr. Squid, are the hardest men to buy for. Every man in my life is very difficult to buy for. Because they are the type of people that if they want it, they just go buy it. They don't talk to anybody about it first. They just go do it. And I have no idea what to get my father. So if anybody has ideas of what to get Papa Squid for his birthday, let me know. I think if it happens again, the sentence will be much, much worse. I also think that the government is trying to make an example out of her, that no judicial immunity does not stop you from breaking federal law. So even though they want jail time, they are making an example that says you do not have immunity just because you are wearing a robe. Plug. Not derailing me today. But somebody said I should invite you on a stream. I don't know what we're going to talk about because you just derail me all the time, but we'll figure it out. Oh, yay! Congratulations. All right. She further concluded that the defendant's 10th Amendment claim required the assessment of disputed facts and characterizations underlying the indictment, which could not be done on a motion to dismiss. Finally, the magistrate judge rejected the constitutional avoidance argument as defendant identified no ambiguity in the charging statutes. Ambiguity always makes me, like, I know how to pronounce it and I know what it means, but for some reason when I see it in a sentence, all of a sudden I can't pronounce it. Immunity. In her objections, defendant begins with the proposition that every act alleged in the indictment is part of a judge's job. I'm not a lawyer. I'm not even that smart. And I can tell you that telling someone that they can evade being arrested is not a judge's job. I have never seen a judge do it. I don't know of any judge that I've followed. Maybe, but Beverly Cannoli or Cannoli, whatever her name is, Auntie Bev in Massachusetts. Maybe she would do something like this, but I don't know any other judge that I've seen on camera. Um, I don't know anybody that would do this. This is not in your job description to allow a person to break federal law. And you're aiding and abetting someone breaking federal law. I just oh, like, oh. And then there, I'm a bad grifter, but my dad's not. If anyone who wants to get me a gift, donate a super chat to Squid or buy a gift towards her house. Okay, there's that. Hey, Hill on top, how are you? In other words, they are all official acts. I hate when people roll their eyes at me, but this whole case right here makes me want to roll my eyes. Because this is just someone thinking that they have more power than they really do. And when these are the type of people that can say, nobody is above the law, nobody is above the law, but the minute they are caught doing some shady shit, try to hide behind every immunity, judicial immunity, I'm a this, I'm a that. So it's the hypocrisy. If people know me, I hate liars and I hate hypocrites. Those are the two people that I cannot stand. The people who will get mad at you for one thing when they are doing the exact same thing. Which is part of my issue in another case that I'm covering with both sides. When one side says, "Well, you're doing this." Well, you're doing the same effing shit. And you're mad at them, but you're doing it too. Yeah. I'm pint size. Well, in height, not stature. She then posits that immunity is not restricted to the civil sphere. But yet, here's my problem with this. It's not she says that it's not restricted to the civil sphere, but every freaking case law that she posted and every case she cited was limited to civil. Like I just that if you say is your immunity is not limited to or restricted to the civil sphere, but then every case you cite is a civil case. She might have cited one, if I'm remembering correctly, she might have cited one criminal case, but I don't believe so. But there might have been one in there, but I can't remember. I can't remember it. The you don't need a law degree to know that something about that doesn't make sense. And that's kind of why I do what I do as a non-lawyer who just looks at legal documents. And this is federal court, so these are not proceedings that are recorded. Although for her initial appearance, we do have the transcript. The transcript was actually released on Pacer if anybody would like to see that. I do have it. So I do have it. So I can purchase it and we can read through it. It protects against criminal liability for most official acts. She admits 3 exceptions to the general rule of judicial immunity. 1, wholly unofficial acts, e.g., a judge who murders his wife in their home or who shares child porn files on his own time. And the fact that she used this example, it's like, why was that the first thing that came to your lawyer's mind to put that in your motion? I mean, uh, I And why cite it like that? Graft or coercive maxi-time gratification for which collateral judicial acts are the inducement or threat, like the judge in Kentucky, who was having smexy time for favors in his chambers, and official acts that deprive persons of their constitutional rights under statutes enacted pursuant to the Reconstruction Amendments, which abrogated judicial immunity. Oh, and there's a footnote there. Defendant concludes that her case involves none of these exceptions. Yet you were, and this is my, okay. So in Fleece's motion that we read the other day, that she kind of argued against her own points, that was arguing against her own point. You say, here's the exceptions to the judicial immunity. However, my case doesn't meet any of those. But you're arguing judicial immunity when you literally say you're like you're like arguing against yourself. And it's like it just gives me a migraine wondering how you make it through a day without, like, I don't know. Hey, Jeff. Judges have a judicial control over their courtroom, but that doesn't forgive intentional illegal actions. Example is the juvenile court judge that was getting kickbacks from private detention. I remember you mentioning that there was 2 judges, I think, that you mentioned the last time we talked about this case. Have a good day. Thanks for hanging out. Ugh. All of the acts alleged in the indictment were done in her capacity as a judge. The indictment alleges no graft or self-interest. I'm thinking that her actions were self-serving because she hates a certain person, a certain orange man bad, so to speak. That TDS is strong, man. That TDS is strong. It makes people lose all sorts of common sense. And do I like everything that man is doing? No. However, that doesn't stop me from having common sense because I don't like certain things that a certain person does. But like these people would be like, can't if somebody in the White House cured cancer right now, they would literally be like, well, now the insurance companies and now the drug companies are going to lose money. That is the type of people that we are dealing with. So the fact that she says she has no self-interest is BS. BS, in my opinion. Such as a bribe or a kickback in exchange for an official act. And there is no allegation that she violated individual rights protected by the 13th, 14th, and 15th Amendments. While the indictment does allege the defendant knowingly concealed EFR and corruptly obstructed the administration of law, which she did, she remains immune from the charged acts as immunity operates to foreclose inquiry to motives. That's an interesting phrase. What do you expect when the mainstream media spreads misinformation as truth? That's true. And that's another reason I have this channel is we read the exact documents. This is one of the reasons that even though sometimes reading these documents is tedious and boring, sometimes I don't like to skip anything because, one, I don't want to be accused of cherry picking like some people do. Not naming names. But if you know, you know, because they only read shit that looks good for their side. Also, I want to read shit that the media won't tell you. I'm not a journalist. I am a occupational therapy assistant. But I can read most days. Most days. Yeah. No matter what the judge says, the video of her proves that she knew she was doing something illegal. Yeah. Dad, what do you expect from Milwaukee County? I mean, that's like, what's his name running for DA of Racine? Why do you think the people in office are against you in the medical help? It's because they are making lots of corrupt money from the companies. And that's one of the reasons I will never work in my field in a hospital again. I would rather work in a gym and work with people. That's one of the reasons I got my corrective exercise certification, is so that I can work with people and keep them from like falling. I can do whatever I can to keep people out of the hospital from a strength, conditioning, and cardiovascular health perspective, and nutrition perspective. If I can keep people out of the hospital from a losing their balance and falling and breaking a bone, because now you break a hip, you're less mobile. Now you're less mobile and you're getting weaker. You're weaker, that leads you to falling more. You're falling more, that leads you to not being able to take care of yourself as much. So you're having to rely on people. You're having to pay for help. If you can't pay for help, now you're going in and out of the hospital with all these issues because your health is failing, and you do that until you die. And that's the circle of our medical care. So my goal is to keep people out. Go get your flower. Get your flower. Get your flower. Get your flower. Grandpa's in the chat. You want to say hi? Okay. Oh, mommy's water always tastes better than hers. Yeah. So, you know. Bye. Yep, I hate the sick care model we have and agree. Yeah, yeah, well, I'll do a stream on things like that, because you remember when you do have like a daily room charge, you are paying for the people who wash the linens, you are paying for the supplies that you need, to even down to wipes, to the antibacterial wipes. You're paying for everything, so you're not, you think it's, those charges really add up. Angel, now we have 3, now we have 4. She got 4. She will still not bring me her actual bubble flower that she can actually have the bubbles. She's brought me 4 of those bottles of bubbles. 4. But she's brought me 5. Go get your flower. We've got 5 of these right here. Which is nice, because I actually needed to store them in this closet in here anyway, but I didn't intend to do it now. She wants me to open them all and play with the bubbles, but she has her bubble wand, or her little flower that sends bubbles up in the air. Because she's toddler's gonna toddler. All right. The government responds to that the Supreme Court has never recognized absolute judicial immunity from criminal liability, and the defendant's assumption of immunity subject to exceptions wrongly inverts the analysis. The government argues that defendant's creation of categorical exceptions to immunity constitutes an attempt to explain away the main historical prosecutions of judges in a gerrymandered way, one which excludes the alleged conduct alleged here. The government further contends that even if a doctrine of immunity for judicial acts exists, the evidence in this case will show that defendant went well beyond her judicial role. Instead, all events arose from her unilateral, non-judicial, and unofficial actions outside the role of a Wisconsin state judge, by obstructing a federal immigration matter over which she had no authority. It's one of those things of like, she had no authority here. She had no authority. Like, she had no authority. That's the thing. Like, you can't hide behind judicial immunity when you had no official authority in what you were doing. Like, you are not an immigration judge. Like, you are it's not stay in your lane, bitch. Stay in your lane. Like, stay in your lane. Uh, oh my goodness. Although the magistrate judge allowed that some of the allegations described conduct that could be considered part of a judge's job, she clarified that defendant was not being prosecuted for opining on the fly, managing her courtroom, or allowing someone to appear by Zoom. Rather, the indictment charged specific violations of federal criminal laws. Specific, emphasis on specific. The government didn't throw a wide variety of charges at her and said, here, we're throwing everything that we can against the wall and see what sticks. The government was very specific in what they charged her with. Very specific. If they would have been too broad, I could see her getting away with hiding behind judicial immunity because they were broad. They were super specific. Ugh. Thanks for our YouTube, not OnlyFans. It's I got a little cleavage. Big. You're fine. Hell, we have APA and AMA neck deep in pharmaceutical kickbacks. So who do you really think physicians' allegiance with is patient? And that's why that's one of the reasons that I always go to a DO if I can help it, not an MD. No offense, Dr. Joe, if you happen to see this. I love my DO is because doctor of osteopathic medicine. Yeah, they do a lot of the same things and they get a lot of the same they get in bed with a lot of the same people as MDs, but their core education is slightly more holistic, in my opinion, than an MD. They get down to the root cause and they see the person as a whole body instead of pieces. So it, stop, don't. Oh, need to wear a turtleneck around you people. No one gets on Megan and her boob shirts. All right. The government concludes that defendant is not immune simply because she encountered federal agents while working at the courthouse. And then the footnote was, to be clear, in the objections, defendant contends that the graft cases are really a subcategory of the unofficial acts cases. I need 10% more disability in order to get in a VA nursing home when I'm older. DO have more extensive training and is holistic. They are okay. Take this with a grain of salt. They are holistic in their education, but when you put a DO in a traditional hospital, in a traditional patient care setting, sometimes the traditional patient care setting rubs off on them. That's why I say they're slightly more holistic. Slightly. Because at the end of the day, yes, their education is more holistic and they see the person as an entire body, not just like MDs see the brain separate from the rest of the body. Like they don't see like the how the emotional side can affect the physical side. Whereas DOs know that your emotions and like say having depression can affect physical pain kind of situation. However, when you put a DO in a traditional hospital setting, sometimes education or not, that hospital setting rubs off on them. So oh my goodness. If you have a condition that warrants getting to the root cause, my neurologist is a DO, but no one knows why MS happens. Yeah, and that's yeah, MS is different for everybody too. That's all right. My neurologist was a my neurologist was a DO, but the head of neurology was an MD. The DO didn't know what the hell was wrong with me, even after an MRI, where the MD, who was the head of neurology, clearly saw what was wrong. So it sometimes it doesn't matter. But generally, if I have to pick between two people with the same exact like years in practice, same qualifications, they've been at this hospital the same amount of time, I'm going to pick the DO over the MD any day. Stub your toe next time you're walking to a VA facility, 10% gain. I was at 80%. I had brain surgery and got 90%. So yeah, that's not always. If it was that easy, I would have done it years ago. Huh. All right. The dispute between parties boils down to this. Defendant posits a general rule of immunity subject to a certain exceptions which account for the previous and legitimate prosecutions of judges. According to the government, there is no general rule of immunity, and what defendant calls exceptions are simply examples of the type of prosecutions that have been brought against judges. A review of the relevant history reveals the government has the better of the argument. Yeah, to the point where he escorted me personally. Yeah, the head of the neurology at the VA in Milwaukee personally escorted me down to radiology so that I can get a full spine MRI. All right. I mean, here, this is, she could have stopped right here. I mean, this is page 5. She could have stopped right here. And then we go back to British law. The concept of judicial immunity is often traced to Floyd v. Barker, basically England, 1607, where a judge who presided over a murder trial was hailed into a rival court and charged with conspiracy for his role. Lord Coke concluded that a judge, for anything done by him as a judge, by the authority which the king hath committed him, and as sitting in the seat of the king, shall not be drawn into question before any other judge, or for any surmise of corruption, except before the king himself. Relying on Floyd and similar English authorities, early American courts granted judicial immunity in civil cases, although at times they stated the rule more broadly. Example, Yates v. Lansing, New York Superior Court, 1810. Affirming Johns 3395, New York, 1811. These are some old cases. The doctrine which holds a judge exempt from civil suit or indictment for any act done or admitted to be done by him sitting as judge has deep root in the common law. In the case of Floyd v. Barker, the subject underwent a solemn consideration by Lord Coke and all the judges, and their resolution was that no judge who tries and gives judgment in a criminal case or does in any act in court was to be questioned for it either at the suit of the party or the king. Yeah, once again, civil. Civil. A judge cannot be sued for finding or sentencing a party to the fullest extent of the law. It's just not Ada K, how are you? How are you, Ada K? Good to see you. We are reading through the motion, the 27 pages of fun these judges in Wisconsin like to write. Of a district judge in the Eastern District of Wisconsin about a circuit court judge's motion to dismiss her criminal case. It is just it's confusing. Hey, Patrick. Oi. We're getting a lesson on judicial immunity and why it doesn't hold up. The Supreme Court first addressed this issue in Randall v. Brigham, 1869, a case in which a lawyer filed a civil action against a state court judge alleging that the judge wrongly removed him from the state bar. Relying on Floyd, Yates, and other authorities, the court found the judge immune, stating it is a general principle applicable to all judicial officers that they are not liable to a civil action for any judicial act done within their jurisdiction. In Bradley v. Fisher, also a civil action brought by a lawyer alleging wrongful removal from the bar by a judge, the court, again citing Yates and Floyd, concluded that a judge cannot be subject to responsibility for a judicial act in a civil action. However erroneous the act may have been, and however injurious in its consequences it may have proved to the plaintiff. I believe these cases are copied and pasted from the magistrate judge's order and decision. I feel like these judges are prepping for their Supreme Court run or their Supreme Court appointment, and they're writing these massive, massive decisions when they don't have to. I'm immune. I've been vaccinated against Patrick W. Hey, Squaw Bob, how are you? Well, that's when these are the original cases that led to judicial immunity. 1607 in England, 1811 and 1869. These are, I'm sure if I went to law school, these would be cases that I would hear about in law school, as to why judicial immunity exists and the case law that supports it. It's just one of these things of like, do we need a lesson on the case law background of judicial immunity every time that we talk about this case? I feel like we've read this entire thing is copy and pasted from the other judge's order. It's just, yes, check out Ada K's YouTube channel. Ada K, how many subscribers are you up to now? Like 10,000? There's a lot of YouTubers who I feel like make really good content and are chronically undersubscribed. Chronically. As defendant notes, a recent civil case also stated the rule broadly. See Rocket v. Amy, 8th Circuit 2023. Judicial immunity continues to apply today, not only in prosecutions like Floyd, but in civil rights actions brought under 14 U.S. Code, or 42 U.S. Code, in my English, 1983, in Spalding v. Vilas, 1896. The court quoted from Yates. But that case involved a claim of civil immunity by Postmaster General, not a judge. As defendant concedes in reply, these references are dicta, but to be fair, some of the language relied upon by the government is too. I have considered all of the case law cited in deciding this motion. Nice! No, it's not, but it's what U.S. law is based on. So, U.S. case or U.S. law in judicial immunity is based on that ruling in 1607 in England. So, like it or not, don't tell Spawn I said this, but like it or not, most of us came from them. And most of our laws came from them. Don't tell Spawn I said that. The court continued, the principle which exempts judges of courts of superior or general authority from liability in a civil action for acts done by them in the exercise of their judicial functions obtains in all countries where there is any well-ordered system of jurisprudence. It has been settled doctrine of the English courts for many centuries and has never been denied that we are aware of in the courts of this country. Hi. Why are you hitting me with a back scratcher? Malin, don't you do it. Ow, ow. You hear how evil she is? She's hitting me with a back scratcher and then laughing about it. Ow. The court also clarified that this exemption of judges from civil liability cannot be affected by the motives which their judicial acts are performed. That hurt. Is this domestic violence if I'm being beat up by a child? So this judge and her lawyer are trying to argue that this is a civil crime, not a criminal one. They did. It's not working though. It didn't make it past the magistrate judge, and then she fought it, and now it's the district judge making her decision, and we shall see. It doesn't sound like it's going very well. That's why our law is so effed up. It's because it came from them. Yep, all countries that were once part of the British Empire follow common law. Elder abuse. That implies I'm old. The purity of their motives cannot be in the way of this subject of judicial inquiry. Pearson v. Ray, 1967, the court granted immunity to a judge sued under 42 U.S. Code 1983 based on his involvement in the prosecution of civil rights protesters. Angel. The court explained, we find no difficulty in agreeing with the Court of Appeals that Judge Spencer is immune from liability for damages for his role in these convictions. The record is barren of any proof or specific allegation that Judge Spencer played any role in these arrests and convictions, other than to adjudge petitioners guilty when their cases came before his court. Few doctrines were more solidly established at common law than the immunity of judges from liability for damages for acts committed within their judicial jurisdiction, as well as this court recognized when it adopted the doctrine in Bradley v. Fisher, 1872. This immunity applies when the judge is accused of acting maliciously and corruptly, and it is not for the protection or benefit of a malicious or corrupt judge, but for the benefit of the public, whose interest it is that the judges should be at liberty to exercise their functions with independence and without fear of consequences. Scott v. Stansfield, 1868. Whew. Throwback. Quoted in Bradley v. Fisher, it is a judge's duty to decide all cases within his jurisdiction that are brought before him, including controversial cases that arouse the most intense feelings in the litigants. His errors may be corrected on appeal, but he should not have to fear that unsatisfied litigants may hound him with litigation charges, malice, or corruption. Imposing such a burden on judges would contribute to principled and fearless decision-making, but to intimidation. What's up, Angel? What can I do for you, boo? What do you need? Do you need a snack? You hungry? What do you need? I will be right back. Y'all grab a drink, take an intermission. I am going to figure out what my child needs, and I will be right back.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals that take us higher. The night's young, it has just begun as she puts her hand in mine. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts running wild. Never sleep, never stop, as we shout from the top. We're gonna be two hearts running wild. Afternoon, we lay awake in bed. The laughs so loud as the hours pass. We're gonna do it all again. We wanna chase
Thanks, guys, for your patience. She wanted me to get down on the floor with her and open her her little human anatomy busy book. So I did. All right. Getting back into this. If this stands for this judge, then all your judges will fall on this insane motion. Yeah, and just remember, this is from the the federal district judge. This is her decision. This is not a motion. This is the judge's opinion and decision. This is just, instead of like Judge Belaytho writes those like 3, maybe 4-page orders and decisions, these judges like to write. They're practicing for their Supreme Court opinions. Power corrupts. Absolute power absolutely corrupts. Yeah, and hey, King Bob. How are you? All right. The court continued in a number of subsequent cases to afford judicial immunity in civil actions brought under 1983, including some with egregious facts. See Stump v. Sparkman, 1978. And I'm going to skip through these. Dennis v. Sparks, Morales v. Waco, and I will post this in the Discord so y'all can, if the size of the document allows me to, because Discord has limits when you don't pay. So we will see. In sum, then a long line of the court's precedents acknowledges that generally a judge is immune from suit for money damages. Morales 502 U.S. at 9, collecting cases. The court, however, has recognized that a judge is not absolutely immune from criminal liability. Ex parte Virginia, that case was mentioned in the magistrate judge's ruling as well. 1880. So the way this is going, it's not going well for Hannah Dugan. Let's put it that way, in my opinion. Or from a suit for prospective injunctive relief. Pulliam v. Allen, 1984. Or from a suit for attorney's fees authorized by statute. Footnote 3, the court has explained that this immunity is overcome in only 2 sets of circumstances. First, a judge is not immune from liability for non-judicial actions not taken in the judge's judicial capacity, which is this. When she acted outside of her, I'm sorry, any way you look at it, no matter if you're on her side, you hate ICE, like you can hate ICE and be all for illegal immigration. Whatever you feel on the subject, you cannot deny that she acted outside her role as a circuit court judge. It is not your role to interfere with a federal agency conducting their business. Like, in her defense, this case is huge as to judiciary immunity, so decision has to be thorough. Yes, it does. Yes, it does. I think it could have been done in maybe like 15 pages and not 25, or 27. But yeah, Discord is an app that everybody, I have a Discord server. A lot of people have Discord servers. You make different like chat rooms. It's hard to describe. Like, I don't know that much about Discord, but it's where I post all that. I need to update it, but I have different folders for different cases that I'm covering. Come on, Angel, Mama's working. Angel, what's the matter, baby? Go. You can go. You're a big girl. Yes. You want to come up here? Get your pad, baby. Okay. Go get Mama hugs. Mama hugs. You want a snack? You just want Mama to get down on the floor with you, don't you? Come here, baby. Come here. Okay, then stay down there. I can't. We're in that we need to take a nap, but we're fighting a nap kind of moment. So nothing's making her happy right now. She's the kind of kid where she'll tell you to sit down on the ground, and then she'll look at you and go sit down. It's like, I'm already seated. Like, I can't sit down anymore. If my order would be sit down and shut up. Yeah, that's what I wish that would be at the end. Like, denied, sit down, shut up. She wants ice cream. That's what she wants. She's not getting ice cream before dinner. I love her, but no. Uh, actions taken in the judge's judicial capacity. Second, a judge is not immune for actions, though judicial in nature, taken in the complete absence of all jurisdiction. Internal citations omitted. The court has also clarified that immunity is justified and defined when its functions it protects and serves, not by the person whom it attaches. Forrester v. White, 1988. In other words, immunity does not attach simply because the defendant is a judge. Angel, I'm not giving you no more candy. I'm not giving you ice cream. No ice cream. No ice cream. I'll have to rewatch this later. I got distracted by something, but you can say Discord is the modern IRC. There's that. The court has drawn a distinction between judicial acts and the administrative, legislative, or executive functions that judges may on occasion be assigned by law to perform. The former gain immunity, the latter do not. Specific holdings of Pulliam have been superseded by statute. Codified as amended 42 U.S. Code 1983, in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. In any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, such officer shall not be held liable for any costs, including attorney's fees, unless the action was clearly in excess of such officer's jurisdiction. However, the court's consideration of common law immunity principles remain instructive, as defendant acknowledges. I discuss Pulliam further below. Awesome. She's crying because she wants ice cream. So if you hear her crying in the background, she's freaking out. Girl. In Ex parte Virginia, a state court judge was charged with excluding Black persons from grand and petite juries. The charging statute provided that no citizen possessing all other qualifications which are or may be prescribed by law shall be disqualified for service as grand or petite juror in any court of the United States or any of the state. It doesn't matter if you're Black, white, Hispanic, or what. You're doing jury duty. Congratulations. On any court of the United States or any state on account of race, color, or previous condition of servitude. And any officer or other person charged with any duty in the selection or summoning of jurors who shall exclude or fail to summon any citizen for cause aforesaid shall, on conviction thereof, be deemed guilty of a misdemeanor and fined not more than $5,000. Yeah, but she doesn't have her iPad. Her iPad's in the other room. Like, so it doesn't. You could FaceTime her all she wants. She's not going to answer. She's not anywhere near her iPad. In declining to grant habeas relief to the judge, the court spent most of its opinion discussing Congress's authority to enact the statute pursuant to the 13th and 14th Amendments. At the end of the opinion, the court briefly discussed immunity. It was insisted during the argument on behalf of the petitioner that Congress cannot punish a state judge for his official acts, and it was assumed that Judge Cole, in selecting the jury as he did, was performing a judicial act. This assumption cannot be admitted. Whether the act done by him was judicial or not, it is determined by its character and not by the character of the agent. Whether he was a county judge or not is of no importance. The duty of selecting jurors might as well have been committed to a private person as to one holding the office of a judge. It often is given to county commissioners or supervisors or assessors. In former times, the selection was made by the sheriff. In such cases, it surely is not a judicial act. In any such sense as is contended for here, it is merely a ministerial act, as much so as the act of a sheriff holding an execution. in determining upon what piece of property he will make a levy, or the act of a roadmaster in selecting laborers to work upon the roads. That the jurors are selected for a court makes no difference. So our court criers, tipstaves, sheriffs, and it is their election or their appointment a judicial act. Huh. But if the selection of jurors could be considered in any case a judicial act, can the act charged against the petitioner be considered such when he acted outside of his authority in direct violation of the spirit of the state statute? That statute gave him no authority when selecting jurors from whom a panel might be drawn for a circuit court to exclude all colored men merely because they were colored. Such an exclusion was not left within the limits of his discretion. It is idle, therefore, to say that the act of Congress is unconstitutional because it inflicts penalties upon state judges for their judicial action. It does no such thing. And remember when that was written, so the context of the language that's used in there, remember when that was written? That was written in 18 something. I can't remember when Ex parte Virginia was. I think it was like 1871 or something like that. So remember that was a long time ago. So you know. So just remember with certain language that's in certain case laws that's cited, when you're reading things, just remember when it was written, and they are just quoting and citing what is written from the past. Just so nobody strikes my channel for using or tries to cancel me for using language that's not politically correct these days. I am literally reading out of a court document. The court returned to the issue in O'Shea v. Littleton, 1974, a case in which plaintiffs sought injunctive and equitable relief against a number of county officials, including 2 judges, alleging ongoing civil rights violations in the handling of criminal cases. The court held that the complaint failed to satisfy the case or controversy requirement imposed by Article 3, and that granting relief would also result in unwarranted federal intervention into state proceedings. The court concluded that the unavailability of injunctive relief did not mean federal law would exercise no deterrent effect in the circumstances. Yes. Thank you, Heidi, for my YouTube is asshat disclaimer. And it's not just YouTube in this particular case. It's people who come into my channel who, 1, don't like me, or 2, have never been here before and don't understand why things are being said that are being said. Like, just remember when we read legal documents and they cite case law, especially case law from the 1800s, there will be language and words that we don't necessarily use today. How? You're beautiful. Oh my goodness. Oh my goodness, boo-boos. You okay? Yeah. You want to say hi? More water? Okay. Oh, you're right there. You see that? Mm-hmm. All right. Judges would willfully discriminate on the grounds of race or otherwise would willfully deprive the citizen of his constitutional rights, as this complaint alleges, must take into account 18 U.S. Code 242, and then cites a whole bunch of case law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant of state to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such inhabitant being an alien or by reason of his color or race that are prescribed for the punishment of citizens shall be fined or imprisoned. Can you say pecuniary advantage? Whatever may be the case with respect to civil liability generally, see Pearson v. Ray, 1967, more case law. We have never held that the performance of the duties of judicial, legislative, or executive officers requires or contemplates the immunization of otherwise criminal deprivations of constitutional rights. CF Ex parte Virginia, I was right. It was 1880, not 1881. On the contrary, judicially fashioned doctrine of official immunity does not reach so far as to immunize criminal conduct prescribed by an act of Congress. Gravel v. United States. See also Imbler v. Packman. This court has never suggested that the policy considerations which compel civil immunity for certain governmental officials also place them beyond the reach of the criminal law. Even judges cloaked with absolute civil immunity for centuries could be punished criminally for the willful deprivations of constitutional rights on the strength of 18 U.S. Code 242, the criminal analog of 1983. Dennis, but judicial immunity was not designated to insulate judiciary from aspects of public accountability. That right there. This right here. That right there. Like, hey, Jen. She's not pulling the race card. She cited she cited a case that was mentioning race because it was around the Civil War. It was after the Civil War. When there was back in the day, there was a judge who was picking a jury, and despite the 13th, 14th, and 15th Amendments, did not choose any black individuals to be on his jury, and judicial immunity did not work there and was found criminally liable and fined. So it's kind of the same thing, not the whole that picking a jury is not a judicial act, and neither is hiding someone from ICE. Yeah, I have mini like a teaspoon of mini M&Ms left in my desk for her. I keep snacks in my desk for her for times like this, and she knows it. So the minute she got up here, she started going through my desk for her. All right. Footnote. This footnote is half a page. While the statements in the case law could be deemed dicta, lower federal courts have broadly denied criminal immunity to judges. See U.S. v. Claiborne, 9th Circuit, 1984. The Constitution does not immunize a sitting federal judge from the process of criminal law. Article 3 protects, though deserving utmost fidelity, should not be expanded to insulate federal judges from punishment for their criminal wrongdoing. We think it is unlikely that judicial independence would be measurably diminished by subjecting judges to the process of criminal laws. See U.S. v. Hastings, 1982. Indeed, the minuscule increment in judicial independence that might be derived from the proposed rule would be outweighed by the tremendous harm the rule would cause to another treasured value of our constitutional system. No man in this country is so high he is above the law. I like that. A judge, no less than other man, is subject to the processes of the criminal law. Citing Dennis, Imbler, and O'Shea, the rule of absolute immunity from criminal prosecution of active federal judges for acts committed in their official capacities poses too great a threat to the public interest in the rule of law to be adopted by this court. U.S. v. Isaacs, 7th Circuit, 1974. The Constitution does not forbid the trial of a federal judge for criminal offenses committed either before or after the assumption of a federal judicial office. Whatever immunities or privileges the Constitution confers for the purpose of assuring the independence of the co-equal branches of government, they do not exempt the member of those branches from the operation of the ordinary criminal laws. Tell that to, Washington. Just saying. Huh. Judges are also subject to criminal prosecutions. O'Shea v. Littleton, 1974. Indeed, the judges here have been indicted by a federal grand jury for the conduct which damages are sought in this case. Stop kicking my stuff, please. You're just doing it before. You're just doing it before, like, you're just doing it on purpose. No. You're just doing it on purpose. Thus, while the court has declined to grant judicial immunity in the context of criminal civil rights violation and cited 18 U.S. Code 242 as an example of a statute that might be used, the court never suggested that judges are immune from prosecution for other crimes involving official acts. The court, would you like this down on the floor? Would you like this down here? Here. Here you go. Baby girl. Here. 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 Beautiful. I love you, but girl, you're gonna fall. I told you, you're gonna fall. Oh no. She doesn't listen to me. We're in the find out portion of the FAFO part or equation. So when I tell her not to do something that she's going to slide or fall, she does it anyway, and I just let her do it. All right. The court has never suggested that judges are immune from prosecution for other crimes involving official acts. The court's discussion in Pulliam further shows that the court has not accepted a common law immunity rule as broad as defendant suggests. Girl, you gotta do something. You gotta, like, yeah, that's why I tell you not to do that. You gotta get down. You're moving too much and you're gonna fall and hit your face. Cutie's little troll. She sits on my lap, but then she moves and she slides on my leggings, and she's going to fall and hit her face on my desk or fall off of my chair. Like, there's not a. Would you like mommy's pad? Go get your pad. Go play your letter game. It's like she hasn't learned to, like, and I know she's 3, she doesn't sit still, but, like, this is not the place to move because it's she's gonna either hit her face on my desk, she's gonna hit her face or hit her head on the wall, or she's gonna fall off the chair. And if she falls off the chair and she hits her head, I will never forgive myself. Here you go. Come on, boo. You got it? Yeah. You got it? Are you sure? Yes. I love you. Okay. Yeah, you're gonna break your face. Like, and that face is so damn precious and cute that I'm like, no, please don't hit your face. I'm like, yeah. Like, please don't hit your face, because even if she slides down, she's gonna hit her face on the drawer. And I'm like, no, please. A judge is one of the hardest people to arrest and prosecute than anyone alive. They have laws to protect them from prosecution. Yeah, and I believe the U.S. so far has done a very good job at putting on their case, especially since she was in the courthouse when she did it and it was on camera. Like, if you're gonna do something stupid and then hide behind judicial immunity even when it's not warranted, make sure that it's not on camera. Can we, like, have we figured out, like, not recording our crimes? Like, I do not advocate for anybody to break the law. But if you are going to be stupid and do something and break the law, do not record it. Just FYI. And hey, Chucky, how are you? Sorry, I never said hi to you. And Dan, how are you? Like, have we not learned? Didn't Mama Mo teach us? Like, when's Mo in the deep end doing another advice with Mama Mo? Because Didn't Mama Mo teach us not to record crimes? If you're going to be stupid and do something illegal, do not record it. Or do not do it in a courthouse that has surveillance cameras in the hallways. Just a thought. Just my thought process there. Oh. The court's discussion in Pulliam further shows that the court has not accepted common law immunity as broad as defendant suggests. In Pulliam, the plaintiff obtained injunctive relief under 1983 as well as cost and attorney's fees under 1988 in an action brought against a state judge. The court surveyed the common law, drawing a parallel between the use of prerogative language or writs of mandamus and prohibition by the King's Bench to control collateral and inferior courts in England, and the ability of federal courts in this country to grant injunctions against state judges. The court further concluded that permitting injunctive relief posed no significant threat to judicial independence, stressing the limitations already imposed by the requirements for obtaining equitable relief against any defendant, absent some basis for determining that such a result is compelled either by the principles of judicial immunity derived from the common law and not explicitly abrogated by Congress or by Congress's own intent to limit the relief available under 1983, we are willing to impose these limits ourselves on the remedy of Congress provided. All right, get to these First judge to be indicted for a crime against the U.S. was in 1862. Dozens have been charged with criminal violations, so it's not unheard of. Charged, but not convicted that I'm aware of. Be it I haven't done a whole lot of research in the how many judges have been convicted, how many sitting judges have been convicted. I don't know who that is. Like, good old rogue judge. And hey, Uncle Buck, how are you? I thought Mo taught us to always clean and chipper after use. I'm pretty sure she taught us that too, but there's been many lessons from Mama Mo. All right. Okay, we have to go all the way back up to. Oh, Jesus, Pete, man, all these footnotes. Footnote 6, defendant argues the court in Ex parte Virginia essentially ducked the immunity issue, holding that the judge's acts were ministerial rather than judicial. The court itself had said this case did more than that. The court assumed that the judge was performing a ministerial rather than judicial function. It went on to conclude, however, that even if the judge had been performing a judicial function, he would have been liable under the statute. So she quoted case law, but she quoted it wrong. I thought lawyers were supposed to be smart. And if you're a lawyer, a judge is a lawyer at the end of the day. If you're a lawyer, if you are a lawyer and your lawyer is submitting a motion for you, would you not want to read it first and say, hey, I have a problem with this area? Or do you just say, here's my money and have a good day? Because her lawyer cited this case wrong, or didn't cite it all the way. It went on to conclude, however, that even if the judge had been performing a judicial function, he would have been liable under the statute. This phrase right here basically takes her whole argument and throws it out the window. You didn't finish the summary of the case. And when you didn't finish the summary of the case, you make yourself look stupid. Many lawyers are unfortunately educated beyond their intelligence. Yeah. I'm just, it's just one of those things. Like, it's why also you actually have to take the time to read the entire case, and you can't just cherry pick shit. Because when you cherry pick shit, you could miss an important phrase, like it went on to conclude that your argument is bullshit. Just a thought. Oh no. Hold on one second. Okay. Oof. Sorry, I just got a text message that I just stopped me in my tracks for a second. And then footnote 7, defendant states that Ex parte Virginia would have been better framed as a recognition of congressional power under the Reconstruction Amendments, an argument in keeping with her contention that prosecutions under 18 U.S. Code 242 are the exceptions that proves the rule. As discussed in the following text, however, the court has never suggested that judges are immune from charges under other criminal statutes, and lower federal courts have regularly held that they are not, as noted above. The court citation, 18 U.S. Code Statute 242, the criminal analog to 1983. I'm going to think about that statement before I go to bed at night. Imbler, in cases like O'Shea, is best understood not as endorsing an exception to the immunity, but reassurance that civil rights violations will not necessarily go unpunished if judges are granted immunity from civil damages under 1983. Tell Jingers to quit texting you. That was my mom, actually. Went down a judge rabbit hole. Thanks, Squid. Glad I could help. Hey, Mom. Glad you're okay. And then footnote 8, as noted above, Congress later amended 1983 and 1988 in response. The court acknowledges in previous holding Pearson granting immunity from damages under 1983, but in that case, the court simply declined to impute Congress the intent to abrogate common law principles of judicial immunity. Absent the presumption of immunity on which Pearson was based, nothing in the legislative history of 1983 or in this court's subsequent interpretations of the statute supports a conclusion that Congress intended to insulate judges from prospective collateral injunctive relief. Apparently, then, the presumption of immunity the court acknowledged in Pearson extended no further than civil damages. Once again, civil damages, not criminal. Not criminal. Finally, the court was unmoved by the dissenter's complaint that injunctive relief carried with it the threat of contempt with the possibility of a fine or even imprisonment, which could deter even the most courageous judge from exercising free and independent judgment. Majority acknowledging that the judge risks contempt for violating the writ of mandamus, finding judge not entitled to immunity from criminal contempt for judicial acts. And then footnote 9. Of course, the requirements for obtaining a criminal conviction are even greater. First, aside from Article 3 safeguards, judges enjoy the same protection as ordinary citizens from vindictive prosecution. Second, a criminal prosecution encounters several procedural barriers, such as the indictment, burden of proof, and presumption of innocence. Yes, but the presumption of innocence is going to go away very quickly when your crime is on camera. Just a thought. It was Pennsylvania. I couldn't remember what state the Kids for Cash scandal was. Against this authority, defendant cites 2 cases for the proposition that there is judicial immunity from criminal prosecution for acts not involving constitutional rights under the Reconstruction Amendments. First is Commonwealth v. Tartar, Kentucky Court of Appeals, 1951, where a judge was indicted for wrongfully and corruptly certifying a list of grand jurors, while a state statute described the manner in which the grand jurors were to be selected. Failure to comply was not made a statutory offense. Instead, the prosecutor argued the judge committed the common law offense of misfeasance in office. The trial court sustained a demurrer to the indictment, and in a brief opinion, the appellate court affirmed. The Court of Appeals first noted that judges acting in their official capacities should be protected from harassment by either civil suits or criminal prosecutions. I do agree with not using the court system as a means to harass somebody else. Ugh. We don't have a choice around here. You know how many times I follow lumber trucks and I'm just like, good Lord. The court then stated, we believe the authorities are generally in agreement that misfeasance of a judicial officer acting in his official capacity did not constitute a criminal offense under the common law. The reasons for such rule are sound, since otherwise judges might be unduly burdened defending charges instigated by other governmental officials or aggrieved members of the public. It is unclear whether the Tartar court found the judge immune or decided that the indictment failed to charge a common law offense against the judge. As the magistrate judge noted, one commentator, after stating a general rule that judicial immunity does not exempt judges from criminal liability, in discussing Tartar stated, the one area where judges can be said to enjoy immunity from criminal liability is malfeasance or misfeasance in the performance of judicial tasks undertaken in good faith. In some states, malfeasance or misfeasance in office is made criminal either by statute or common law rule. However, this criminal liability will be precluded by judicial immunity unless the malfeasance or misfeasance is accomplished by bad faith. Jeffrey M. Shaman, Judicial Immunity from Civil and Criminal Liability, 27 San Diego Law Review, or Revision 1, 18, 1990. I know I screwed something in that up. If this is indeed the rule, it is inapplicable here. The defendant is not charged under a state statute or common law prohibition on malfeasance or misfeasance in office, but rather a federal criminal statute of general applicability. At all events, Tartar is a thin reed upon to rest a claim of criminal judicial immunity, subject to narrow exceptions. The other case is U.S. v. Chaplin, Southern District of California, 1944, where a judge was indicted for conspiracy to deprive civil rights under a predecessor to 18 U.S. Code 242. The court, surveying the case law dating back to England and distinguishing Ex parte Virginia as a case involving ministerial acts, agreeing the judge was immune from prosecution. The cases upon which the court relied were generally involved civil immunity. The Chaplin court cited Commonwealth v. Addison, Pennsylvania, 1801, which involved a criminal accusation against a judge, but the Addison court did not explicitly rely on immunity, stating in full, we are unanimously of the opinion that the case does not present our consideration an indictable offense, and of course, this is not a case in which an information ought to be granted, but we are, with the same unanimity, English, I cannot pronounce that word today, I apologize. Of opinion that every judge has a right, and emphatically, that it is his duty to deliver his sentiments upon every subject that occurs in court. We add, so far as the expression of our sense of decorum may have weight, that we think it would be indecent and improper in any presiding judge to attempt to prevent his associates from exercise of this right from the performance of this duty. Motion refused. All right, this big long footnote. In a more recent article, Professor Combs states, whereas American law provides judges absolute immunity against civil lawsuits, it provides no immunity whatsoever against criminal prosecutions. This little one figured out how to flip upside down on the bar over her trampoline, and it scares the ever-loving crap out of me. Redressing judicial misbehavior, an integrated approach to judicial immunity. UC Davis Law Review, 2024. The bottom line is judicial immunity is bipolar. It's not the only thing around here that's bipolar. Judges are entirely shielded from civil money damage suits, but they have no shielding whatsoever from criminal prosecutions. By contrast, judges possess no immunity whatsoever from criminal prosecutions. It is uncontroverted that the doctrine of judicial immunity does not shield judges from criminal liability for their judicial acts. An overview of judicial immunity, including legal representation of judges. It is axiomatic that common law judicial immunity has never been extended to shield a judge from criminal liability. All this to say, judicial immunity applies to civil, not to criminal. This is where I'm like, y'all are long-winded. Because shit. It's 27 pages to write something that should take half of that. And cite just as many cases and be just as thorough. But not nearly as long. Good off topic here. The man in Florida unalived 3 people during a bad U-turn. How the heck is the company's insurance going to say and or do? I have no idea. Not a clue. And the fact that he didn't really speak English, and I believe he's not in the country legally, I believe is a whole nother can of worms. They have to earn the Bloviated Jurist Award. I could see Flea tripping over the word axiomatic. Some of these words come out, and I'm like, I'm surprised that came out okay. And then some of these words that should not be hard, I'm like, do what now? I'm like, in my head, I can pronounce it. But then when I try to say it out loud, I'm like, excuse me? That's true. That's true. Sort of. However, when you are hiring someone, they also need documents to be able to work in this country. And I don't think he had those either. But I could be wrong. So, in that case, you blame both. That said, somewhat tangentially, some cases have held the misfeasance of a judge when acting in his official capacity does not constitute a criminal offense. One federal court suggested, citing Tarter, that there may exist a common law immunity from criminal prosecution for acts done in the judge's official capacity, undertaken in good faith. I don't think anything that she did on that day was in good faith. I think she was blinded by, I hate ICE, I hate Trump. Let's do everything I can to circumvent this crap. And then hide behind judicial immunity. I think that she thought, and this is strictly my opinion, I believe that she thought that she could hide behind judicial immunity to get away with anything and pretty much do anything. I think she knew that what she was doing was wrong, but she thought she could hide. And then being in Wisconsin, and a lot of these judges were appointed by Clinton, Obama, Biden, that she would get backup from the federal judges who were appointed by Democrats. Just a thought. The Chaplin Court did make a strong policy argument that judges should be immune from criminal civil rights prosecutions just as they are from civil damages actions. And my whole thing with only talking about who appointed these judges is, as a judge, we are supposed, I'm not a judge. Judges are supposed to be impartial and only interpret the law as written. But we've seen judges who are interpreting the law as their they want it to be written, or what their ideology and their groupies think it should be written as. You should not know or wonder who appointed a judge. And the fact that we do, and that's the first thing that comes to mind, was who appointed this judge when they made a decision, is a bad thing, in my opinion. It's a really bad thing when the first thing you look at when a judge makes a decision is who appointed them. Yeah, judge grudge. I mean, but that goes for all over the country. Like, the first thing you look at is like, who appointed you? Like, when you're making these decisions, who appointed you? And when you start looking at judges by that, it's like, that's how you know the world is fucked up. The immunity which has clothed judges for a century and a half in our country found its genesis in the English common law simultaneously with the independence of the judiciary. The disappointed litigant cannot embarrass the judge in civil action for damages irrespective of the justice of his decision, nor can a defendant upon whom sentence has been pronounced recover damages against the judge for the real or supposed wrong. A decision in favor of the government in the instant criminal actions would place the official action of every justice of the peace, municipal, city court judges, superior court judges, appellate court, Supreme Court judges in our country at the mercy of a United States attorney. Every sentence imposed on a defendant would be subject to review by the representative of the Department of Justice, and if, in the judgment of the Attorney General in the United States or the U.S. Attorney for the district decision, you want to go get it? Okay, my doorbell just rang. I will be right back. Thank you for your patience. It was my Walmart delivery. They from the warehouse. They actually rang the doorbell, which is so weird. They never ring the doorbell. But I ordered a 12-pack of this. It is so delicious. So delicious. So delicious. Oh. All right. Let's see, where was I? Every sentence imposed on a defendant would be subject to review by the representative of the Department of Justice, and if the judgment of the Attorney General of the United States or the U.S. Attorney for the district, the decision deprived the defendant of his civil rights, the judge can be invited, tried, and if convicted, punished. Every defendant sentenced to the county jail or the penitentiary is deprived of his civil rights. This is basically saying that, like, if judicial immunity didn't exist, every time a judge made a decision, an attorney could review it and then the judge's ruling would be subject to the Department of Justice. That's basically what this is. So yeah. We're only on page 17 of 27, so I'm going to be skipping around a little bit. Not cherry picking, but significant as those concerns might be, it's hard to square Chaplin with subsequent cases like O'Shea. Judges who would willfully discriminate on the ground of race, otherwise would willfully deprive the citizen of his constitutional rights, as this complaint alleges, must take into account 18 U.S. Code 242. And Imler, even judges cloaked with absolute civil immunity for centuries could be punished criminally for willful deprivations of constitutional rights on the strength of 18 U.S. Code 242, the criminal analog of 1983. Criminal analog of 1983 is something that's going to haunt my dreams. Ugh. Bye, Malin. Bye. As the magistrate judge noted, indeed, even defendant acknowledges that judges are not immune from prosecution for official acts under civil rights law. In some, then Chaplin also provides little support for defendant's contention here. Here's the kicker. Here's where it gets funny to me. Finally, defendant appeals to the recent decision in Trump v. U.S., where the Supreme Court held that president is entitled to absolute immunity from criminal prosecution when exercising his core constitutional powers. Yes, as the president, powers as the president, not powers as a circuit court judge in Milwaukee County. There's a slight but oh so obvious difference. I mean, if I need to explain to a circuit court judge in Wisconsin the differences between absolute immunity as presidential powers and judicial immunity as a circuit court judge in a county in Wisconsin, we got more problems than just her hiding behind judicial immunity. Just a thought. And at least presumptive immunity for all his official acts. Defendant contends that the court relied on judicial immunity cases for official acts, extending to the president what judges had first. Oh, boy. The Trump decision relied primarily on the president's unique position in the constitutional scheme as the only person alone who encompasses a branch of government. At the end of the day, the president and the vice president are the only two people in the executive branch who are elected. Think about that. With as many people who we have in the executive branch, and think about all the people or the departments that are encompassed in the executive branch, when you boil it down, the only two people here, let's do a little 7th grade civics lesson here. The only two people in the executive branch who are elected are the president and the vice president. Think about that and try to sleep at night. The court concluded, based on separation of powers principles, that immunity was required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. These same concerns do not arise when one of the nation's many judges is subject to prosecution. Yes, how many judges are there compared to how many presidents there are? At the end of the day, a circuit court judge in Milwaukee is a pretty low-hanging fruit, so to speak. Further, while the court relied on its previous decision in Nixon v. Fitzgerald, granting the president immunity from civil damages actions, a decision which in turn cited Pearson v. Ray, the court said nothing about criminal immunity for judicial acts. Ultimately, as the Supreme Court stated, the official seeking of absolute immunity bears the burden showing that immunity is justified for the function in question. Burns v. Reed. See also Antoine v. Byers and Anderson. The proponent of a claim to absolute immunity bears the burden of establishing the justification for immunity. Defendant has not done so here. Woo! This is not going her way. This is not going her way. Footnote 12, we have been quite sparring in our recognition of absolute immunity and have refused to extend it any further than its justification would warrant. In her objections reply, the defendant argues that under Pulliam, the burden is not on her to demonstrate that Congress or the U.S. Supreme Court created judicial immunity in criminal cases. The burden is on the government to show that the original criminal judicial immunity has been abrogated. However, this assumes that the court in this country have accepted a common law rule of criminal judicial immunity in the first place, as discussed above. I know that this judge was appointed by Clinton, but I actually like her. They have not. See Combs Supra at 1174. The bottom line is that judicial immunity is bipolar. Judges are entirely shielded from civil money damage suits, but they have no shielding whatsoever from criminal prosecutions. Defendant argues that the reasons for judicial immunity are stronger in the criminal context. It is true that consequences for a judge, if criminally convicted, will likely be greater than if she is found civilly liable. And while a public employee can be indemnified for damages judgment, one cannot shift and ensure the loss of liberty that comes with a criminal conviction. This is why we always read the footnotes, because this judge seems to be putting all of the case law in the document and all of her opinions on the defendant's motion to dismiss in the footnotes. This is why you always read the footnotes. So to the lawyer on YouTube who said, I never read the footnotes, you're an idiot. And if you have been watching LawTube for 2 or 3 years, you know exactly who I'm talking about. Sorry, had to laugh at that for a second. However, as Professor Combs explains, criminal prosecutions and civil suits differ in key ways, and these differences go a long way towards justifying the current doctrinal dichotomy. Combs Supra at 1217. Civil suits present a greater threat to judges than criminal prosecutions, both because judges are far more likely to be the target of a meritless civil suit than a meritless criminal prosecution, and because the risk of a judgment against a judge is higher for a civil suit. Thus, because civil suits present a greater threat, immunity from these civil suits provide greater benefits, including to the value of judicial independence. First, disappointed private litigants are far more likely to bring a civil suit against a judge than a prosecutor is to launch a criminal prosecution. Second, a far broader range of harms are compensable as civil wrongs than are punishable as crimes. Third, it is easier for a plaintiff to win a civil case than for a prosecutor to secure a conviction on the same facts. Yes, because a civil suit, you only need 51% assurance that they did it or didn't do it. Criminal, you need beyond a reasonable doubt. That's a large burden to overcome. Given that the different burden of proof. Finally, the civil tort suits exist primarily to recompense individual victims who have suffered harm, whereas criminal prosecutions not only vindicate the rights of the individual victims, but also society as a whole. Consequently, immunity from criminal prosecution imposes costs not just on the individual victim of the judge's wrongful act, but also on the larger community. Defendant concedes that the Supreme Court had never had the occasion to apply judicial immunity from criminal prosecutions for official acts outside the context of civil rights protected by the Reconstruction Amendment. But this is so, she contends, because prosecutions like this one have so rarely been attempted. You're not helping your own case. Oh, I can't have footnotes. I wash my feet every day. The particulars of this case may be unusual. Nevertheless, as discussed above, the magistrate judge's recommendation, there is no firmly established judicial immunity barring criminal prosecution of judges for judicial acts. Footnote 14, Jesus, Pete, man. Okay. Oh, we skipped an end. We had to skip an entire page to finish the footnote. This is not to gainsay the very real concerns the defendant raises. She wonders why, if official acts enjoy no immunity, a judge could not be prosecuted for handling contraband during a trial or scheduling a hearing in a manner that inconveniences federal law enforcement officers. Saying that it's not the way the criminal justice system operates and that it is a matter of common sense, operatives in this system would not violate the criminal law if they are in good faith carrying out their required duties, as the government does, is unsatisfying. As the 11th Circuit noted in permitting the prosecution of a judge for bribery, I believe somebody in the chat mentioned this. This is not a case in which a judge is prosecuted for acts in his official capacity undertaken in good faith. In such a case, there may exist a common law immunity from criminal prosecution. Hastings citing Brayleton v. United States, Commonwealth v. Tartar, but this leads to the government's fallback position that the defendant is not being prosecuted for official acts in the ordinary course of her duties. Instead, the government contends the events alleged in the indictment rose from her unilateral, non-judicial, and unofficial actions outside the role of a state court judge. I agree with the government for once. While it would be improper to consider facts outside the four corners of the indictment on a motion to dismiss, viewing the facts that are alleged in the light most favorable to the government, as I must at this stage, and accounting for the indictment's allegation that the defendant knowingly concealed EFR and acted corruptly, I cannot say as a matter of law the defendant's alleged conduct falls within even the more limited version of immunity. U.S. v. Joseph, Massachusetts, 2020. Of course, any such immunity, if it exists, would never shield corruption or bribery. Where the indictment charges that Joseph acted corruptly is not within this court's province on a motion to dismiss to determine whether judicial immunity, even if it's in its reach, encompasses criminal liability, provides a viable shelter for Joseph in the criminal or circumstances alleged here. There should be a word limit on footnotes. Change to foot chapter. I know, right? Like, we have to go all the way back up. See, we have to go all the way back up for here for footnote 14. Or in a hypothetical closer to the mark, could a state court judge be prosecuted for obstruction if she remands an undocumented person into custody to answer for state charges, thereby thwarting a planned arrest and removal by federal immigration agents? That's I understand that this judge has to be thorough, but like this judge and the magistrate judge just like to hear themselves talk. Maybe it's a female thing. I'm not really sure. Because Florida is not, maybe it's Florida, maybe it's the judge, but damn, every female judge I've read an opinion on or an opinion by just likes to hear themselves talk. Where even Bolitho and Bolitho's district judge are sort of straight to the point. The district judge is a little more wordy, but straight to the point. This is 27 pages. We've been at this 2 hours. 2 hours, and we're only 20 pages into this. And yes, I'm stopping, and yes, I'm getting distracted, and yes, I'm giving my opinions on it, but like, I am trying to just read. But I'm also trying not to be super ass boring because, you know, remember Judge Grudge, he loved to hear himself talk and talk. Yeah, but he had a separate, he thought he was smarter than everybody else. I'm not getting the arrogance from these judges that I've got from Judge Grudge. There was an arrogance that I on Judge Grudge that he's like the smartest person in the room. I'm getting like teacher vibes. Like, I know this. Here, let me teach it to you. From these judges. Maybe it's a female versus male thing where like male just exude arrogance to me. Like, a side note, Mr. Squid sent me an article or an article today, and he said, watch the video at the 2-minute mark. He made the news. I screenshotted it and I sent it to somebody, and they go, he doesn't look very happy. And it's like, RBF. The man has mad RBF. You think I look pissed when I'm just sitting here? And that's kind of died down. When I've had other people on the panel and I'm just listening to them talk, I've had less people tell me I look like I'm angry. However, he looked like he has RBF. Like, you think I have RBF, man? Yeah. My parents can tell you. Mr. Squid looks like he's angry all the damn time. To the point where even I'm like, are you okay? And I've known the man 20 years. Hey! And hey, Rickles, how are you? Still better than reading a BBB filing. Not as funny, though. Like, there's not as much to make fun of. And as much as I enjoy, like, learning, I do enjoy learning. It's like, sometimes I'm like, okay, we got this lesson the last time. Sometimes we want to get straight to the point, you know? All right. I'm going to skip that footnote because it's just case law. So there is no basis for granting immunity simply because some of the allegations in the indictment describe conduct that could be considered part of a judge's job. As the magistrate judge noted, the same is true in the bribery prosecutions conceded valid, where the judges were prosecuted for performing official acts intertwined with bribery. Defendant argues that gravamen of the offense in such cases is accepting of the bribe, an unofficial act, with the collateral official act done in response presented as an evidentiary detail to complete the story. The cases do not support this distinction. See, Hastings. In this case, we are asked to decide whether an active federal judge can be subject to federal criminal prosecution for acts involving the exercise of his judicial authority. Wallace, holding that a judge had civil but not criminal immunity for his judicial acts. It's her basically just multiple cases that say civil but not criminal, civil but not criminal, civil but not criminal. It's honestly, whatever's written here, that's all my brain can process out of all of these things is civil, not criminal, civil, not criminal, civil, not criminal. So nice try, but no. Or as the government puts it, a judge may use judicial acts or tools as a means to accomplish unlawful end. Finally, to an extent, the defendant argues this category of cases requires the judge act for the purpose of self-enrichment or gratification. She provides no authority for the proposition that the motive must be financial to be corrupt. And as to the extent the defendant contends a court cannot inquire to the judge's motive for judicial acts, the same could be said in the bribery cases. Accordingly, even if a more limited version of a judicial immunity exists, it does not support dismissal of the instant indictment. I mean, yeah. Here's our foot book. As defendant notes, Justice Barrett discussed the issue in her partial concurrence in Trump. However, her views did not carry the day in any event for reasons stated above. Trump is an opposite. 17, Professor Combs notes that a few cases suggest criminal acts somehow cease to be judicial acts. However, the earliest example, Bradling, is discussed in note 15 above, involves a situation where defendant's criminal acts were distinct from his judicial acts. Fortunately, only a few courts implied that criminal judicial acts somehow ceased to be judicial acts. And then 18 is also worth noting that the question is not whether the charged acts are part of a judge's job, as the Supreme Court has made clear. Judges enjoy immunity from civil damages for their judicial acts, but not for the administrative, legislative, or executive functions that judges may be on occasion be assigned by law to perform. I mean, this. All right, the 10th Amendment. Oh, here we go. This 10th Amendment argument just made me laugh, if I remember. In the objections, defendant contends that the magistrate judge missed the importance of the 10th Amendment here. She argues that outside the context of the Reconstruction Amendment Enforcement Clause, Congress lacks the authority to punish criminally the official acts of state judges. However, defendant cites no authority for the proposition that federal criminal statutes of general applicability may not be applied to state court judges. She basically said that the federal separation of powers, the federal government has no power of law enforcement. Like, it. She basically said that nobody can prosecute a judge because they don't have law enforcement capabilities. It was weird. It was just weird, and I couldn't. Things that make you go, what the F? There's some things that make you go, and there's some things that make you go, what the actual, like. It is true that Constitution establishes a system of dual sovereignty. Prince v. U.S., 1997, although the states surrendered many of their powers to the new federal government, they retained a residual and inviolable sovereignty, which is reflected in various provisions of the Constitution, including the 10th Amendment. And the Supreme Court has enforced limitations on the federal government's ability to intervene in state affairs. But none are plainly applicable here. For instance, the indictment in no way suggests the federal government may commandeer state judges into assisting in the enforcement of federal immigration law. Yeah, ICE didn't ask her to detain them. All she had to do was not tell them that ICE was there. Plausible deniability, and just let them leave through the regular doors. She wouldn't have been in any trouble. It's so stupid. All of this is just so stupid and unnecessary. Not from the federal government's perspective, but like, all she had to do was just let them leave and not talk to ICE and tell ICE that they didn't have any power there. Like, just let them do their job and go away. You just go back into your chambers, mind your business, and this would not be a problem. But now look at you. Not like the judge will ever see this, but now look at you. Like, Jesus, Pete, all this could have been avoided if you just didn't have like massive TDS. Nor does the indictment assert federal power to superintend the daily functioning of state courts, whether this case involves the routine work of a state court and judge, as defendant contends, or whether the defendant added extraneous activities to her usual duties in order to defeat enforcement of federal immigration law, as the government alleges, is not something that can be decided on a motion to dismiss. See Joseph. At bottom, the defendant's constitutional arguments require the assessment of disputed facts, characterizations of the events underlying the indictment, or other evidentiary analysis. The state law permits the discipline of judges for ethical violations, as defendant notes, does not preclude bringing of federal criminal charges. Rejecting the argument that Congress has the exclusive primary jurisdiction to try and punish a federal judge for high crimes and misdemeanors through the impeachment process. The impeachment process, something that's not used enough with our court system. Let's see. Before we read another book. Isaacs, rejecting the argument that impeachment rather than criminal conviction is the only means of removing a judge from office, nor does one indictment against one judge result in the usurpation of Wisconsin's power to select, discipline, and remove its own judges. Defendant cites Gregory v. Ashcroft. Ashcroft is, I don't know, like, isn't it Ashcroft v. Twombly that's cited in every federal federal 2 motion?
Mama,
Angel?
I take it.
No more candy. No more candy.
I take
When mommy's done here, we're gonna get dinner, okay?
it.
Yes.
Mama.
Oh, mommy. Where the court declined to apply age discrimination and employment act to Missouri state court judges, absent a clear statement that Congress intended to interfere with the state's power to define the qualifications of its own officials. Again, permitting this prosecution to proceed poses no similar threat to Wisconsin's sovereignty. Girl. Holding that denial of an evidentiary privilege to a state legislature or prosecuted for federal crimes is not analogous to a direct regulation of state employees' wages, nor does defendant cite any authority for the proposition that a clear statement from Congress is needed before a criminal statute of general applicability may be applied to a state official. In reply, defendant cites the recent decision in U.S. v. Illinois, July 25th, 2025, where the court... No, that's not... No. No, it's not lipstick. It's a dry erase marker. You dropped the cap. You gotta get the cap. I know she was about to tattoo herself with her icing for her cupcakes. Her plastic cupcakes. I thought that for appointed judgment, impeachment with a recommendation for charges sent over the DOJ based on the findings of the impeachment. I'm actually not exactly sure the full process for circuit court judges. It's a problem because I think it has to go through the state legislature as well. I'm not sure. No, she was going to tattoo her lips. It's like she was going to use it like lip gloss. Like, no. Where the court dismissed the government's complaint against the state of Illinois and various local entities and officials challenging so-called sanctuary policies. The court noted that the term sanctuary policies is a misnomer, and none of them immunized anyone to the reach of the federal government. Instead, they generally prohibited state and local government support of civil immigration activities, complying with detainers, giving immigration agents information about non-citizens. The government claimed these policies were designed to, and in fact, interfered with the government's enforcement of federal immigration law. The court engaged in a wide-ranging discussion of preemption and intergovernmental immunity, ultimately concluding that sanctuary policies reflected the defendant's decision not to participate in enforcing civil immigration law, a decision protected by the 10th Amendment and anti-commandeering doctrine. As indicated above, the instant indictment commands no one to participate in federal immigration enforcement. Rather, it charges obstruction with those efforts pursuant to a statute of general applicability, not one regulating states and their political subdivisions as cited in this cited case. I mean, this judge is pretty much laying it on, like, you're not getting out of this that easy. Sorry about your luck. Avoidance. Finally, in the objections, defendant alleges ambiguity in the terms corruptly and proceeding used in count 2. Presumably, the court would construe these terms such that Statute 505 does not apply to the conduct alleged, avoiding the need to determine whether the federal government could, consistent with the 10th Amendment, use ordinary criminal statutes to target state judicial acts. The canon of constitutional avoidance comes into play only when, after the application of ordinary textual analysis, a statute is found to be susceptible of more than one construction. The canon functions as a means of choosing between them as to avoid constitutional concerns. Clark v. Suarez-Martinez, 2005. In other words, the canon is a tool for choosing between competing plausible interpretations of a provision. It has no application in the absence of ambiguity. Warger v. Shars, 2014. Defendant cites no case finding these terms is used in 18 U.S. Code Section 1505 and further defined in 18 U.S. Code Section 1515b, ambiguous. Instead, she relies on Snyder v. U.S. 2024, where the court held that 18 U.S. Code Section 666, which makes it a crime for state and local officials to corruptly solicit, accept, or agree to accept anything of value from any person intending to be influenced or rewarded for an official act, covers bribes but not gratuities. As part of its analysis, the court did note federalism concerns with a more expansive construction of the statute. As state and local governments had adopted a variety of approaches in regulating their acceptance of gratuities. And just going into this, and the people that I've seen support her, or a state judge breaking federal laws. Yeah, I felt kind of funny reading that. And I'm a bad Christian, but still, I felt kind of like I needed to not clutch my pearls, but clutch my cross at that time. It's a whole lot of sorry about your luck, but I don't think it's gonna work out for her. But from the people I've seen supporting this judge online and citing the 10th Amendment, clearly have never read the Constitution. There's plenty of people who cite the First Amendment, the Second Amendment, the Fifth Amendment, and clearly know nothing about what that amendment says. So, it's funny when people cite the Constitution, and I'm like, you've clearly never read it. It's been a while for me, I admit. I haven't read it, passages of it, in probably 5 to 10 years, and then haven't read the whole thing in probably 15 years. But I've read it before. Definitely read it in high school. The court declined to rely on the government's promise that federal prosecutors could be trusted not to enforce the statute against small-time violators. As noted, however, the issue in Snyder was whether Section 666 covered gratuities as well as bribes. The court did not find the term corruptly to be ambiguous, nor did the courts address the canon of constitutional avoidance. Moreover, as the government notes, defendant cites no authority. Once again, there's certain things that she talked about that she didn't cite any case law for. Defendant cites no authority for this court to decide non-constitutional statutory interpretation questions on a motion to dismiss. Finally, even if it would be appropriate to address the issue now, defendant posits no competing plausible construction of the statutory terms. Rather, the issue she raises regarding whether the conduct alleged is covered by the statutes are properly addressed at trial. Most of Congress doesn't understand the Constitution. You have taken the oath that never expires. Yeah, that is true. That is true. Footnote 20. To the extent the court considered the term, it did so in concluding that Section 666 is a bribery statute, therefore dividing the line between 201B's bribery provision and 201C's gratuities provision is the bribery requires that the official have a corrupt state of mind. And this is a problem with people with statutes and things, is you don't actually know anybody's state of mind unless they tell you. And most people are not going to tell you what they were thinking when they did something. Section 666 shares the defining characteristics of 201B's bribery provision, the corrupt state of mind, and the intent to be influenced in the official act. The statutory text therefore strongly suggests that Section 666, like 201B, is a bribery statute, not a gratuity statute. Therefore, making her argument null and void. The bribery statute for federal officials, 201B, uses the term corruptly, but the gratuity statute for federal officials does not. The term corruptly, therefore, signals that 666 is a bribery statute. I do like how this judge explains things. Like, it's like A plus B equals C, and A plus C, like, the way she does it. Like, hey, 201B uses this and is a bribery statute and uses this terminology. 201C is not a bribery statute, does not. So therefore, it only makes sense that Section 666 is bribery. It's like, she explains it very well. Lots of words, but very plain English, so to speak. And footnote 21. To the extent the defendant raised additional issues in making her avoidance argument before the magistrate judge, I agree with the magistrate judge's analysis. Conclusion. Here you go. All of that for this. Therefore, it is ordered that the magistrate judge's recommendation is adopted and defendant's motion to dismiss is denied. It is further ordered this matter is scheduled for an in-court hearing on Wednesday, September 3rd, 2025 at 11 a.m. to address further scheduling. Not the news that Hannah Dugan wanted. However, it's the news that she's going to get. So she's going to be in court September 3rd, 2025 in Milwaukee's federal courthouse. If anybody who watches and is in Milwaukee or near Milwaukee County, including any of my family who watches, wants to go, because that is next week, just so if someone like works down the street from the federal courthouse and can take an early lunch, just a thought, and want to know or want to give me cliff notes on how this goes, let me know. Just in case anybody, just in case, and if you think I'm talking about you in the chat, I probably am. This judge had one of the math teachers she was in elementary school, and that said, show your work, and she complied. This judge also was appointed by Clinton. Think about that for a minute. This judge was appointed by Clinton. This judge is older. Probably next in line. She's a district judge. She's not a magistrate judge. So she's already made that climb. She is probably one of those people who is like, the next time a Supreme Court seat is up, she is probably going to be one of those people who is like, hey, look at me, look at me, look at me. So yeah, Milwaukee is now Wisconsin's now a purple state, not to mix political leanings in, but political leanings seem to have direct input on judicial findings. Yeah, and I never want to, people on this channel know my political leanings. I don't hide them. However, I'm a very, I don't care who you are and what your opinions are, as long as you can back it up with fact. However, I'm also don't let your hatred for one person mess with your ability to use common sense and think clearly. And that's what's happening. People are letting their hatred for one person impact their ability to think clearly. The people, Chucky, the people who say, well, illegal immigrants aren't criminals. Do you not understand what you just said? They broke the law by getting here. They broke federal immigration law. So whether you like it or not, they could be the greatest people in the world and be some of the hardest workers in the world. It's not the point. You go to any other country in the world and you're there illegally and they're going to deport your ass. Canada is going to deport your ass. Mexico is going to deport your ass. So why are we the only people who can't enforce our own laws? That's the weirdest part. Why are we the only people who are every ist in the book if we enforce our laws? Everybody else can do it. Never be considered for SCOTUS unless she's on the Federal Court of Appeals. Well, she might be moving up in the world. So, I mean, yeah, Milwaukee's a heavily Democrat city. More Democrats are in favor of just letting them in. But Waukesha County is immediately west of Milwaukee County. And Waukesha County is heavily Republican. So, smaller city. But the county itself, it's all the people who work in Milwaukee but don't live in Milwaukee because Milwaukee sucks. I know people who live in or work in Milwaukee and live in Racine County. I know people who live in Milwaukee or work in Milwaukee and live in Waukesha County. And same goes with Ozaki, which is north. So, you know, they watch Reese's and like stay in country. Like, yeah. And then not UK, the minute you get pulled up in a hotel and give free stuff. Yeah, Clinton, I like working under the bench. All right, on that note, it is 4:30. I've been at this for 2.5 hours. I have to get going. I am going to see who else is that is live that I can redirect you to. Let's see. I do have the Hannah Dugan playlist. This video will be added to it. I will be adding this video to that, and I will be adding the other videos or the last video to the description of this video if you want to check them all out. Ooh, Camelot and Mr. Squid is home. Tell Camelot that I said hi, and I will see you guys on the next one. Bye.